All rise. Court of Appeal in and for the 5th District in the state of Florida is now in session. The Honorable Brian D. Lambert, Judge, presiding. All persons having business before this court drawn here, your attention will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Just housekeeping, Aaron. Do not hear clear button. Does that mean something to anybody? Or you have a clear button? Oh, there it is. All right. I don't think I've ever hit it in 10 or 11 years anyway, so I guess we're good. But I'll remember not to do it today. I'll probably do it now that I'm looking at it. So what happened? Okay, good morning. Welcome to another session of oral argument here at the 5th DCA. You heard our marshal introduce me. I'm Judge Lambert. I'll preside over the session this morning. On the panel with me, to my right is Judge John Harris, and to my left is Judge John McIver. So maybe I'll change my name to John too. You have 3 Johns here. So, all right, we have 2 cases. Just for the date, for the record, it's September 17, 2024. We have 2 cases this morning. One is at 9 and one is at 10. Each side will have 20 minutes to argue. We'll reserve 5 minutes for the appellant's rebuttal unless you tell me you would like some other amount of time, and I'll set the clock accordingly. We are being videotaped, or we are on Instagram, whatever, we're on something. So just guide that in your discussions or your comments, so we are being watched. So also, if you have any type of cell phones or other electronic devices that may go off, please either turn them off or put them in the mute position so that it does not interfere with either your argument or your opponents or with the court's questioning. Okay, that being said, first case we have this morning at 9 is number 23-2176, Maroy Sims Jr. versus State of Florida. So, appellant, whenever you're ready, approach. Good morning.
May it please the court.
Yes, ma'am.
Laura Sapir on behalf of Appellant Maroy Sims Jr. We're here today on...
Do you want 5 minutes, or you want a different amount of time for rebuttal?
5 minutes, please.
Okay, that's fine. All right, go ahead.
We're here on 5 grounds for relief in this case, appealing the judgment and sentence for Mr. Sims. I want to address grounds 1, 2, 3, and 5 together since they have some overlapping issues. And those concern ground 1, statements during closing argument implying that Mr. Sims was involved in organized crime or a criminal enterprise. Ground 2, which the state misrepresented an agent testifying about the chunkiness of the substance being indicative of cocaine. And ground 3, the officer giving testimony talking about the risk of robbery in a case like that. For these grounds, a lot of the issues are similar. So grounds 1 and 2, it concerns facts not in evidence and misrepresenting testimony. Ground 1, there was no evidence whatsoever that Mr. Sims was involved in organized crime or a criminal enterprise. This was one sale. In ground 2, there was no
They never used the word organized crime, right?
They did not. They used the words organization, organized, enterprise, but this is a criminal case, so there's no way a jury could hear that and not think of organized crime or a criminal enterprise.
Well, I mean,
Organized crime has its own connotation.
Yes, it does, and I think when we're talking about, most people think of mafia, but people also think of, a drug organization as well, a drug cartel.
well, contact. I mean, there was 2 people apparently involved on the side of the selling of the drugs, right? So is that not it's some kind of organized event between the 2? Could that not be a fair interpretation of that comment?
Yes and no. So there could be an argument that there was some organization to it, but I think that would be more appropriate for sentencing, for example, if there was a downward departure argued for sophistication, isolated sophistication, and remorseful. But at this stage, it's not pertinent to the guilt phase.
But all of these things are unobjected to, so we are at the highest, you have to show fundamental error.
Yes, yeah, we're dealing with fundamental error, and that's kind of why I grouped them together, because they all, reviewing it in the context of the record, they all kind of, it almost seemed as if the state was arguing all of the counts, even though it was just one count in this case. They were talking about, on this day, this is how the organization worked. That implies there were other days where sales were made. They talked about him being a businessman, how he set up an organization. And I think that's kind of why it goes to the fundamental errors, because we're talking about other bad acts and collateral crimes and stuff that was not being tried here. I mean, that...
Mr. Sims referred to himself as a businessman? Or did at least talk about his customers?
He did, in a degree, but I don't think it's so much the businessman or the business on its own. I think that exacerbated the error, because the true error is going back to organization, enterprise, in those terms. And it does go to the main issue and the main defense, which was that he did not know the illicit nature of the substance. And the jury apparently found that important, because they had a juror question about, is he required to know that the substance is cocaine?
Didn't Mr. Sims talk about a half a kilo in his negotiation posture with the undercover officer?
Sure, but the jury still had a question about it, which indicates that they were unsure on that.
But I mean, your point is, your defense is Mr. Sims didn't know what the half kilo of stuff he was selling?
That was the defense that was raised at trial, yes, and that was the issue that the jury was concerned with.
And you're concerned, I mean, you're mentioning that the officer was referring to it as chunky, and the officer apparently testified that he had lots of undercover cop experience dealing in drug transactions, and this type of cocaine is chunky. Is that not something he can testify about? Or,
I don't think
he did testify about it because it was unobjected to, but you're saying that's a fundamentally erroneous thing to him to have done.
Right, and I don't think that he testified that cocaine, or that chunkiness is indicative of cocaine. I think he said it was chunky and pure and all that, but I don't think that was something that was explicitly testified to. I think that
So if it was chunky and pure, he's just describing the thing that he bought for, I don't know, what, $19,000 from your client?
Yeah, but he didn't testify that it was indicative of cocaine, and I think that's particularly important because he was not only a misrepresentation of what the officer testified to, but because he is law enforcement, the jury would give greater weight to that. And that goes as to the issue in ground 3, which was that there was a risk of robbery. And again, with that, it's not only irrelevant, it's also non-responsive. The question was whether the undercover operation was considered a larger operation. They didn't ask if he had to take extra precautions, and I know that the state argues in its answer brief that it explains why he counted the money, why he marked it to see if it was counterfeit. That goes, I mean, I did that as a cashier when I worked in retail. Like, that doesn't indicate that there's a risk of robbery. That has nothing to do with it.
You said there's a risk of robbery to both sides, the one with the contraband, purported contraband, and the one with a large amount of money. So he was saying in those transactions there's a risk that one of the two sides might not play fair in their consummating their transaction, right?
Sure, I mean, there is a risk, but again, it doesn't go to the issue of guilt. It really is irrelevant, and the probative value is substantially outweighed by the danger of unfair prejudice, which is that Mr. Sims has propensity for robbery or for violent crimes, and that was not anything that he was charged to. There was no evidence of violence. There was no guns. There were no threats, nothing like that.
Well, let's assume it's an off-the-cuff comment in the testimony that was not directly responsive to the question that the prosecutor was asking. Did the state never argue that oh, by the way, you know, look at this as a cocaine transaction and robbery might have taken place. I mean, they never mention robbery in their closing.
They did, actually, Your Honor. On page 134 of the trial transcript, they said everyone is afraid of getting robbed. So they did highlight on that testimony, or, yeah, that testimony.
That's the one highlight, is that what you're saying? That's the one instance in the closing?
Yes.
Okay, I apologize for misstating that.
No problem. And then as to ground 5, which is cumulative error, as I said before, while the state is entitled to wide latitude in its comments and its closing argument, that doesn't justify improper arguments, that doesn't excuse improper arguments. And here it seems like, as I mentioned before, that it was deliberately calculated to suggest that there were other crimes, this was an organization that occurred on other days, this is how it happened on this day, and it just kind of influenced the jury to think that this guy is doing this all the time, and whether he is or not is not the issue. That's not what was at bar. It was one count that was charged. It was one transaction, and they tried to make it seem like it was multiple transactions. Moving on to ground 4, the state conceded in its brief that it is improper for the trial court to consider pending charges as part of sentencing. So in light of that, I'm going to move forward to what is the analysis for whether the error is reversible. So in
Didn't we just recently have a case, when you were on that case? Nelson or something like that?
Yes.
Yes,
We just
and-
released an opinion in like a month or so ago?
Yeah, and we filed a notice of supplemental authority on that to bring it to the court's attention. But
He's helpful to you? I mean, I appreciate your candor to the court and all that. I didn't read that case to be overly helpful to your position.
No, but I think-
Tell me otherwise, then.
There's a huge distinguishing factor, and that's preservation. In Garcia, which is the case that Nelson relied on, they, yes, abrogated the rule that it's not per se fundamental error. However, in that case, they note, in light of Garcia's failure to preserve the issue, appellate review is conditioned on the finding that the trial court's alleged consideration of Garcia's post-arrest misconduct constitutes fundamental error. So that's why the fundamental error analysis applies.
I mean, in Garcia, the Supreme Court, didn't they kind of basically say, I mean, they analyzed the issue about considering impermissible factors, but they also kind of referenced to the federal court world that it's talked about all the time, apparently, in federal court. And that doesn't seem to cause any constitutional angst in the federal court system. Do you agree that that was the observation of the Garcia Supreme Court?
Sure, that was an observation in the court, but also noted in Nelson and Garcia is that the primary case that found that it is impermissible to consider sentencing factors, that was Norval. They noted that it wasn't expressly overruled. So that still applies. They're saying it's impermissible, period. So although it was considered in the argument in Garcia, I don't think that changes the rule, the bright line rule that was established by Norval.
Well, didn't Nelson basically also say, okay, yeah, impermissible factors not good, crimes not convicted of or other uncharged crimes, whatever, but that there has to be some record indication that the judge actually relied upon that compared to, I think the strain coming out of Norval was if it's put in the air, then the state has to prove, even if the judge makes no mention of the impermissible factor, using the term impermissible factors, the state then has the burden of proving that the judge didn't do that, even if the judge didn't open his mouth and say, I'm sentencing you to this, because you got all these other cases pending too, and so you're just a bad dude, so.
Right, yes.
Nelson seems to say there has to be something that the judge just did what I just said, as opposed to it's in the air, like the Shelko opinion that I wrote.
Right, and I would disagree that Nelson says that what has to happen.
Shelko predated Garcia and all that, and Garcia kind of.
Right, so in Nelson, it says that when determining whether a court relied on impermissible sentencing factors, it is primarily the court's express rationale. And that might be the general rule, but I also have some cases where essentially what happened is the court did not make an express rationale, but they also did not provide or explain any factors that influenced their decision. So that would be Lundquist.
So are you saying then if the parties make their presentation, the state either directly or indirectly submits impermissible, quote, impermissible factors for the consider, and the judge says, okay, everybody done? Yes. All right, my sentence is this. Good luck, have a nice day, and he or she walks out, that because the judge hasn't explained herself or himself, that the impermissible factor analysis is still in play post-Garcia?
Yes, and that's because the burden, again, is on the state.
So then, and following that logic then, the judge then has to affirmatively announce that I am now sentencing, I've heard the argument, I will not rely upon impermissible factors at all, I will sentence you to, you know, imposes a lawful sentence. Is that how you say the status of the law is to quash any argument about the impermissible factor discussion?
I mean, that's one way that it could be analyzed.
Another
However,
way, then.
if the court perhaps doesn't expressly say, I'm not relying on impermissible factors, if they instead give an explanation for the rationale.
As one of the factors that you might look at where within the acceptable range of sentencing the sentence actually fell, as an indicator of whether the judge actually relied on the impermissible factor or not.
Sure, that could be a factor. However, here, what the sentence was, he scored a little bit less than 8, the minimum mandatory was 15, and the judge gave 23. So without any
The
factor...
state asked for 30.
Yes.
And there was a min-man of 15, regardless of what he scored absent the min-man.
Right.
It was going to be between 15 and 30, and the judge, you know, split the proverbial baby in half, for lack of a better cliche.
Sure, and I do recognize that there was the minimum mandatory, but without some explanation of why the judge is going above that, we don't know that it wasn't the impermissible sentencing factors that they considered. They gave no justification to go above the minimum mandatory, and it was...
So you're basically saying the judge has to announce that they're not doing that. If the judge gives a permissible sentence, not what the state wants, not what the defendant wants, somewhere in the middle?
No, I think if the judge, they don't expressly have to say that, if they give some other reason for why.
But the judge doesn't have to give a reason, right?
Not necessarily, but when we're considering a sentence above the minimum mandatory, above the score sheet, you know, that would be evidence to the state to overcome their burden. I'm not saying the judge has to do anything. However, if this...
I look at it with somewhat ironically because, you know, having, and he's not on the criminal bench anymore, but we certainly have a judge over in Citrus County that we wish would stop talking over the years when he was imposing sentence. So, you know, there's a benefit to trial judges and to appellate review if the judge just says, I thank you very much. I have heard your arguments. I impose this sentence, and it's, you know, it's a lawful sentence. And then,
Sure, but
that's what I'm having a hard time wrapping my head around your argument, is that if the judge doesn't have to affirmatively disavow this, and he or she is permitted just to simply say, thank you, here's your sentence, good luck, have a nice day, that somehow then becomes problematic on appeal if the state doesn't prove that the judge utilized an impermissible sentencing factor, even though the judge gave no indication whatsoever that he or she did that. I mean, that seems to have a hard time following what Garcia is telling us.
Sure, but I think, again, this goes back to a serious and important constitutional right, which is not to be sentenced for stuff that has not been proven in court.
That goes back to I mean, I know there's a fundamental error, but it still goes back to the question, if you're the defense attorney, why don't you stand up and say, hey, tell the prosecutor judge to stop saying, oh, by the way, they're talking about a lot of things this person never got convicted of, and you can't consider that. I get it as fundamental error, and I get you don't have to be the objection, because I get all that. But, you know, it certainly, you should have the sense of the direction of appellate world, as we're guided by the Florida Supreme Court, that everybody better start objecting and moving for rehearing and telling the trial judge about things, so that So that makes our job easier from a standpoint of, okay, we know exactly what the specific issue is. It was raised and was ruled on one way or another, and that's the fuss that we have in appellate land.
Sure, and I understand that fuss. I would ask that I reserve the remainder of my time for
thank you.
rebuttal. Thank
Sure.
you.
Yes, ma'am, thank you.
Good morning.
Good morning.
May it please the court?
Yes, ma'am.
Marissa Giles on behalf of the state. I'd like to start off where this panel just finished and then work our way backwards. So starting with the sentencing issue.
Well, we usually work backwards anyway, so go ahead.
Perfect. So starting with the sentencing issue, while we did concede that considering pending charges would be error, we did not concede that that occurred in this case. It cannot be reasonably read from the record that that did occur in this case. Specifically, the trial court said absolutely nothing when making its sentencing, a proper, lawful sentence in the middle of the, as Your Honor said, split the proverbial baby between the min-man and the maximum. So there's no evidence that the court considered impermissible factors, considered those pending charges. The mere fact that the state mentioned that there's pending charges does not indicate that the trial court considered them, and that's what the Nelson case says.
I'm just curious, do you all ever talk to your prosecutors at the trial court level and say, you know, we usually end up winning these appeals anyways, but you stop throwing the hurdles in the track and stop doing that stuff?
I have not personally, discussed that with the prosecutors. As a former prosecutor myself, I know that when you're in the middle of it, it's difficult to kind of separate, especially when there's 20 counts in one information, and this is just one count out of the entire information. But it's clear that the trial court didn't consider it. And, even if the state did bring it up, the defense counsel brought it up first. He said, there's 19 other pending charges, Your Honor. We're going to ask for the min-man. So, we would make an argument there that even if that was the case, that it was invited in a sense. But, the Nelson case explicitly says it's not the state's argument that wins the day. It's what the trial court said. And there's no indication here that the trial court considered the pending charges or any impermissible factors. So we would argue that there is no need for a resentencing here. And then I guess we'll start with the risk of robbery comment. So I guess that's testimony. I guess their argument is testimony and argument. We'd argue that that's not fundamental error. Sergeant Orby Ryan was talking generally about the risk of robbery. He was qualifying his answer about...
He wasn't asked about robbery. The officer just kind of, in the course of responding to a question, said, oh, by the way, when you got a big transaction, there's a risk on both sides.
That's true, yes. He was not specifically asked about it. I would argue that he was kind of qualifying his answer. He's talking about his experience with large drug transactions going undercover, and he's, saying, I've got $19,000. This guy has, however many kilos of cocaine, half kilo of cocaine. There's clearly a risk of robbery on both sides. So while it may not have necessarily been the best comment, the best testimony, I would not argue that it was overly prejudicial to the defendant. Clearly, there's a risk of robbery when you're walking around with $19,000 and a half kilo of cocaine. But even if it was error, it's not fundamental. There's no evidence, and there was no testimony that there was a risk of robbery in this case, specifically to the defendant. He was speaking about it generally. Sergeant Orby Ryan said nothing about, I was worried about being robbed by Mr. Sims. I was concerned. It kind of just goes to explain the entire criminal event, why he did what he did, and why Mr. Sims did what he did. So I would argue that it's relevant. It's not overly prejudicial, and even if it was, it's not fundamental. Error does not vitiate the entirety of the trial by any means, especially since that brief mentioning and closing that my opposing counsel mentioned was very, very brief. It was not dwelled upon, and it was just a very minor comment. So then I guess these last couple comments we have, they kind of all encompass each other. The comments on the enterprise and the organization, the businessman comments, the chunky quality of the cocaine. We would argue those are fair comments on the evidence. Clearly, this was organized. They had met before, they had organized a price, they had organized a meeting place and a time. All of that was in evidence through all those recorded calls. Mr. Sims kept the cocaine off site, and after the money was counted, he had it come in. All of that is clearly organized, and it would be a fair comment on the evidence to say that it was organized. Organized, enterprise, those are words that legal technicians use to talk about organized crime, but there was no implication here that this was organized crime.
What if the prosecutor said organized crime?
Did he say organized crime?
No, I don't think the prosecutor did, but if that was a comment with that,
I think that would be a different scenario than we have here. The prosecutor here never said organized crime. If he had implicated organized crime, that would be, I think, a different discussion, but that's, the word organized means, things are well planned out and put in place, and that's exactly what occurred in this case. And it wasn't improper for the prosecutor to say that it was organized, because it clearly was. Anybody watching the entire video of the crime, which, was before the jury, could clearly see that this was an organized enterprise, for lack of a better word.
I find it somewhat ironic when I was referring to that Citrus County judge, the one case I wrote about, he decided that he wanted to look at the cocaine himself, and he commented it was some Colombian cartel quality cocaine, even though it was some stupid transaction off of some dirt road in Hernando, Florida, which is about 43 people in Hernando, Florida.
Right.
And somehow that judge, somehow he cleaned that from that transaction.
Yes, he knew based off the chunkiness.
That became problematic for him, for the case.
Yes, I'm sure.
But,
Moving on to the quality of the cocaine, the fact that it was chunky, clearly that's not an improper comment. That was in evidence. Sergeant Orby Ryan testified to the fact that it was chunky. It's on the video. Mr. Sims himself refers to it as chunky and pure. Clearly that was indicative that this was cocaine and not baking soda or powdered sugar.
well, what do you think about their final argument, the cumulative? If I guess is if you have three, count ground 1, 2, 3 are this were fundamentally erroneous comments, and if them individually are not fundamentally erroneous, if you package them up, do they cross the line? Is that an applicable scenario in the context of ground 5 of their argument?
We don't think so. We do not believe that this would amount to cumulative error. We don't believe any of these are problematic.
Is it the principle is if you have 3 comments that in and of themselves don't reach the level of fundamental error, but then combined, can that be problematic, I guess, for the state's position that, if you just did one of them now, but you did 3, combine them all, A plus B plus C equals fundamental.
We would not say that is the case in this case.
You say that in any case?
No. Perhaps, if it was egregious, but this is not egregious.
If it's egregious, then it's fundamental by itself.
Right.
That's not the point.
But, if we look at the entirety of this closing, these comments that we're discussing are very minimal. This was not a main feature of the state's case by any means. The main feature of the state's closing and of the state's case is the entire crime is on video and is before the jury. And it appears from the record that they're watching the video and the prosecutor is walking through what's happening in that video. So these minor comments about being a businessman or about organization, none of those things are going to amount to cumulative error in this case because the evidence was so clear. There was all those recorded phone calls. The entire crime's on video. They have the cocaine. They have that Cheez-It box that it was brought in. It's just not amounting to cumulative. It's all harmless for lack of a better term, based on the quality of evidence they had and the fact that these were very minimal comments. And if this panel does not have any other questions?
Anything else?
Oh, I will rely on my briefs. Thank you very much.
Thank you, counsel.
And I ask that you affirm.
Lucky you got that one in. We wouldn't have been able to figure that one out. All right, counsel, you have 253.
Okay. Moving back to the sentencing issue, I think there's some important things to point out. The state argued that there's no evidence that the trial court considered it. And again, the burden is on the state in this case. I also want to point out that while there were no comments by the trial court as to what factors she considered, this was the state's entire presentation. It was 99% of their presentation, if not 100. So if no other factors were presented, what else did she have to rely on?
Can you point to any, so I had brought up sentencing range as one example of something that might be a nonverbal indicator that the judge considered it. Can you point to any other indicator that the judge did consider it?
No, I mean, the only thing that one could assume by looking at the whole of the record is that they were convinced and compelled by the state's argument, which the argument was it's an ongoing criminal enterprise. He does this all the time. He's a danger to the community because he's going to keep dealing. And, you know, he has such a nonchalant attitude about it. It's because this is what he does. This is normal for him. So in light of that, I mean, that was their entire presentation and their entire argument.
What about the state's argument that defense counsel brought it up first?
As to,
Had 2 more counts to deal with, or whatever was said.
well, I don't think that invites the error. It's just explaining the status of the remainder of the case. Obviously, he didn't ask the court to consider that or not consider that. He just said, oh, by the way, there's more counts. And, I mean, honestly, if the trial court wanted to punish him for the remaining counts, they had the opportunity to do that if he got convicted on those counts. There's no reason for the court to consider it twice in count 6 and then again in whatever counts he gets convicted of. I mean, that's just, that goes against, you know, the fundamental principles of justice. So in that case, I would assert that it's not invited error. The state is the one that chose to go into the details of it and argue why it would warrant a higher sentence. Defense obviously didn't do that. There's no reason for him to do that. Obviously, he argued for a 15-year minimum mandatory. Going back to the robbery issue in ground 3, the state posits that it is relevant to it.
In a very broad sense, is commenting on the deterrent effect of sentencing the same thing as improperly considering uncharged crimes, uncharged future crimes in sentencing?
No, I don't think so. I think deterrence is an adequate consideration for sentencing. That's in the case law. However, I think it is distinguishable for pending crimes because it's like, I'm going to punish you for this stuff that you allegedly did, even though it has not been proven yet. So that's where I think the distinction.
I'm going to sentence you so that you won't keep dealing drugs, I think was the implication that you were saying was improper here.
Well, the indication is that he's done this multiple times, and yes, that he could continue doing it, but I think the primary focus is like, he's got all these other counts. That's what the consideration is.
Okay.
Okay. All right,
Thank
counsel. Thank you very much.
We would ask that the court reverse and remand
There you go.
for new trial or resentencing. Sorry.
All right, thank you. All right, our next one's not till 10, so we'll come back at 10. So we'll stand adjourned till 10 o'clock.
Rise.